All right, let's look at estate administration. This is the process after someone dies of converting property that is in the decedent's name to the respective beneficiaries under a will or heirs under intestacy. Estate administration deals only with probate assets. All right, so as part of wrapping up Chapter 5 and the trust overview, some of the issues that we looked at is the requirements of a trust, examining those requirements to determine if a trust exists at all. If so, identifying when it was created, because we have different rules depending on whether or not it's created during the settler's lifetime in terms of an irrevocable inter vivos trust or revocable a trust that is created at death, or testamentary, which is created at death. And we need to know that because of various requirements that we're imposing on the trustee, dispositive provisions, evaluating whether or not we have any future interests to which RAP applies. If so, identifying the future interests if they are contingent remainders, vested remainders subject to open or executory interests, then applying common law RAP. Trust management, we looked at various express provisions and also discretionary provisions. As long as the trustee is not acting in bad faith, the test is abuse of discretion. And keeping in mind, trustees, once they are appointed, are fiduciaries in which various fiduciary duties follow. The overview of the estate administration process is essentially that an estate is opened. Once the estate is opened, a personal representative is appointed and letters of administration are issued. The letters of administration allow the personal representative to go into the bank and say, I've been appointed as personal representative. I want to close the decedent's account. So that is the point of having a document that is authorizing someone else who's alive to act on behalf of someone who has passed away. So the first thing that happens is the letters of administration are issued as a result of opening the estate. Various paperwork is required. The next step is the inventory and information report. The inventory shows the register of wills, what assets the decedent had, what probate assets the decedent had, and their date of death value. The information report is a separate form that discloses to the register any probate assets or non-probate assets, like a revocable trust, that's subject to an inheritance tax. And that inheritance tax is paid depending on whether or not there's a will with a tax clause or no will, in which the respective heirs receive the property net of tax. The administration account is sort of like a balance sheet. This is what we start with, this is what else came in, this is what went out, and this is what is available for distribution. So in a nutshell, that's the estate administration process. Keeping in mind there are two types. You would prefer the administrative, in which you are dealing with only the register of wills. Judicial means that you've got to go to court for some form or for some reason. In most jurisdictions, there is a separate orphans court. In a few jurisdictions, the circuit court takes over what would have been the orphans court responsibilities. But you will mostly be dealing with the register of wills and possibly an orphans court. You would want to go to their website and look at their forms. You can complete them online and save them. Nothing is being submitted electronically yet, but I'm sure that is something that will be happening down the road. It is very, very informal, and they are very, very helpful, keeping in mind that both the Register of Wills and Orphans Court are elected positions. So they really do their best to try to keep their constituents happy. Again, just looking at the process, think of it as a three-part process. Opening the estate and being appointed as personal representative, filing the inventory and information report where you're disclosing to the register the assets of the decedent and paying any necessary inheritance tax on non-probate assets, and then filing a administration account, which is, this is where we started, these are the assets that came in, these are the expenses we made, this is available, this is how we propose, this is what is available for distribution, and this is our proposed distribution that in fact gets approved by the orphans court, and then distribution can be made. If anyone is upset with this process, there is a way in which you can file an exception to the account if you represent a beneficiary as opposed to the personal representative.